Welcome to the Art of Discrimination Self-Defense podcast series, Chapter 5, the formal investigation stage of the EEO process. I am your host, Randy Williams. In this podcast, we will discuss your formal investigation. This stage is extremely important because the written report that results from the formal investigation will be your first official evidence, which is the foundation for all subsequent stages in case processing. This is where EEO cases are torpedoed, ultimately resulting in dismissal or a finding of no discrimination. So please pay attention. Our mission is to share impactful knowledge that in effect helps people overcome the oppression of unlawful discrimination, because unlawful discrimination must be stopped. Hello again, and thanks for listening. In previous podcasts, we discussed stages in the pre-filing of an EEO complaint, the filing process of an informal EEO complaint, and the importance of ADR mediation. If your case was not resolved in the informal stage, your case should move into the formal investigation stage of the EEO complaint process. I will first cover the private sector process because that is more straightforward. Then I will explain how this investigation stage works in the federal sector. If you are in the private sector and mediation fails to resolve your case, the EEOC must conduct a limited investigation and will share those results with you in writing, usually in a formal letter which gives you the right to file your case in district court. It is very straightforward and limited in supportive documentation on your behalf. Usually in private sector cases, the EEOC reports are basic and relatively inconclusive. You will have to gather your own supportive evidence. So upon receipt of that EEOC investigation report, you will have 90 days to file your case in district court. This time frame is expressed in their report. Always plan on eventually filing and arguing your case in court because the EEOC will not make the argument for you. Court will also give you an additional opportunity to engage in settlement discussions up front because courts love to encourage mediation as it helps reduce caseload. So be ready to offer settlement terms immediately after filing in court. Now, if you're in the federal sector, the steps are a bit more murky and treacherous. I will explain. In the federal sector, you must submit your formal complaint to your agency's civil rights office, per the instructions provided from your agency. Your formal complaint will include your contact information and will list the basis, the why, the issue, what happened, and a remedy of what you want as a result of your complaint. In deciding whether to accept or dismiss your complaint, your civil rights office should only look at the technical aspects of your case. For example, did you file your informal complaint within 45 days? Were you tangibly harmed? Did you formally file within 15 days? They are not supposed to consider the merits of your case, which determines whether discrimination actually happened. The subsequent EEO investigation will record the merits of the case, indicating discrimination or not. If you don't meet the technical requirements for the formal complaint submission, your case will be dismissed. But you can appeal that dismissal with the EEOC's Office of Federal Operation, the OFO. I'll cover that in another podcast. However, if your formal complaint meets the technical requirements for formal filing, you will receive a complaint acceptance letter which states what the agency believes your EEO complaint is all about. You then have a short amount of time, exactly 5 days, to make any adjustment to the way your complaint is framed or interpreted. That framing dictates the life of your complaint, also known as the legal target. So please take time to read how they summarize your complaint. For example, I have seen cases in which people believe their case is about a hostile work environment and a non-selection. Yet the acceptance letter only covered one item, the hostile work environment or the non-selection, not both. So the excluded issues would not be considered, processed, or judged later. Don't get set up for failure because of faulty acceptance letters. Carefully read the acceptance letter to ensure it accurately covers all the issues you raise as unlawful discrimination, or get it corrected immediately by timely advising the Civil Rights Office of the error. Once you receive your complaint acceptance letter, usually in the mail, you will enter the formal investigation stage. You will then be contacted by an EEO investigator whose mission is to create your record of investigation, the ROI, which is the first court-admissible documentation of your case. The ROI process begins with you providing your initial statement, followed by management's response. Then you have the right to reply or rebut to what management has just said in their defense. It is kind of like a tennis game where you serve the charge first, management defends by sending back their statement to you, then you have the last word in rebuttal. The investigator should also gather witness statements, background information, and any other information relevant to the case definition taken from your complaint acceptance letter. Your goal as the complainant is to drive the ROI process, in which you, the complainant, have the first and last word on the discrimination you experienced. I honestly can't tell you the number of times where this does not happen, where complainants are routinely cheated as investigators cut corners to limit their testimony and make management look good. Remember, the EEO investigator is not your friend. After all, they're paid by the agency that you filed against, not you. I've seen many instances where management had the first word and/or complainants were never afforded the opportunity to rebut or reply to what management said. So the eventual record of investigation was one-sided in favor of management. Don't let that happen to you. The EEO complaint process is about you and what discrimination happened to you. Don't get cheated, and with my help, this will never happen. Now, let's talk about how to make your initial and rebuttal statements. Investigators can do interviews and/or send you written questions for written response, depending on their preference. Either way, you want your initial statement to be very direct in terms of what you experienced and what you believe happened that was discriminatory. This is not the time for being polite or expecting reviewers to automatically understand what you went through. Be brutally honest. Don't worry about being politically correct. Think like you're dealing with a hostile audience that does not want to believe you, so take your best shot at providing your evidence of discrimination. This is not the time to be humble. This is your first chance at an official record. You want people to believe you, so clearly point out what happened to you or what was done to you. Remember, use comparators or people that were similarly situated to you, but they were treated differently and better than you, with the only difference being they were from a different demographic group, such as race, age, sex, and so on. That's the definition of discrimination. Stress your demographic status as listed in the acceptance letter as the reason that management treated you differently and less favorably. Don't expect a reviewer to make that leap. You have the burden of providing proof that you were discriminated against. For example, if you believe management cheated you out of a promotion or denied you an award, you should clearly state they cheated you and point out that other coworkers, comparators, were not cheated. Your statement needs to be pointed, direct, as it will be shared with management for their direct response. By the way, management will always defend or try to justify what they did to you in their written response to your initial statement. That's why rebuttal of their response is extremely important. Now, let's discuss your rebuttal statement. They call it an opportunity for rebuttal, but it is extremely essential to your case. A rebuttal allows you to ambush what management has said in their defense of your initial statement. It is perhaps the only chance you will get to show that their statement contains lies, distortions, mischaracterizations, tricks, all meant to hide or mask the discrimination that they did to you. You must show that their words don't hold water, then explain why. Again, you can use witnesses, documents, or just plain common sense to reveal the holes in management's defense. The better you do in the rebuttal stage, the better the chances are for subsequent complaint settlement or a favorable judgment. Never miss out on a rebuttal opportunity. I have been a discrimination complaint investigator, both public and private sector, for 25 years, including managing an office staff of investigators. I can tell you there are many systemic incentives for EEO investigators to make your case look weak and management's position strong. For example, some agencies use contract investigators. These contract investigators are paid thousands of dollars for each case. If that investigator wants to keep getting cases assigned, you can believe they'll try to avoid creating investigation reports where management looks bad. These are some of the reasons complainants are rushed and bullied through the investigation stage. Don't kid yourself. Your case is seen as nothing but a widget being pushed through a factory designed to turn your case into a dud. If you need more time to provide your statement and/or rebuttal, make the request in writing. They can't deny reasonable time for you to prepare your statements. If you're interviewed, make sure you review and agree with what the investigator recorded as your statement. Don't let the investigator threaten you with dismissing your case. As long as you are responsive and work with the investigator in writing, they can't say you are failing to cooperate, so your case may be dismissed. Lastly, at the conclusion of the investigation, make sure the investigator has your correct mailing address because the record of investigation will be mailed to you. Along with that record comes a letter explaining your rights to next steps. You don't want to miss any subsequent timeframe deadlines because of lost mail. I will explain those next steps in Chapter 6 of the Art of Discrimination Self-Defense. That concludes our Chapter 5 episode. In Chapter 6, we will discuss your next steps after your case investigation and you have received your record of investigation. These steps are like crossroads, where each road offers a different case path. I will briefly explain each pathway so you can make the best path decision on what happens next in your case. In the future, with your support, I will provide webinars designed to help develop and present EEO cases during formal investigations. Thanks for listening, and please share with others. Now, here's Angelia Williams, production manager for our Art of Discrimination Self-Defense podcast audio series. She will show you how to support our efforts in fighting unlawful discrimination. Take care of yourself.
Hope you've enjoyed the show. If so, please hit the subscribe button. Have any questions or comments about this episode? You are welcome to start a discussion. If you need case representation, please email directly. Contact information is found below. You can find additional resources on how to support our efforts in the episode description. Thank you.